And I can certainly say in my own experience in the courtroom, dealing with people, I've done quite a bit of thinking and work with young people especially, who come from these very traumatized homes in the inner city environment, whose families have fallen down, lost to alcoholism or struggling with it. And it's always important to me when I deal with these young people to never say something, which I've always heard in law practice, and I always hear, and I always say, never say this, which is, this is your last chance. The judge will always say that to them. This is your last chance. If you steal another package of gum, we're really going to come down on you. We can never say that to people. A non-Indian official in the system can never say that to an Indian person, because you don't know the situation that those young people have been in order to just cope and survive and make it to a courtroom. And we have to always bring into the justice system this understanding of their situation. So there's no last chances. Whoever gave us in life a last chance to be able to say that to someone else? We always have to look at the root causes of why is this happening in this person's life. There may be more traumatic things happening to them outside the justice system than inside the justice system. Certainly with the young people with disabilities like fetal alcohol syndrome, they probably are not even, there isn't even a school that will accept them to go to school. They may not have a home, they may not have a nutritious meal, a warm place to sleep. The idea that they come to the justice system to be treated in a certain way like everyone else is a problem in this society and in our community, where that is the majority of people who come through the courtroom. So the whole philosophy needs to be looked at very deeply, very carefully. In terms of innovation, I think Saskatchewan in many ways is a national leader in community-based approaches to justice. And this is the irony. 90% of the First Nations in Saskatchewan have partnership agreements with the Departments of Justice in the province and federally to have justice committees at the community level. We have many innovative policing projects. We have Aboriginal court workers. We have conditional release programs. We have offender reintegration programs from the penitentiary correctional side. We have healing lodges. We have many institutions based on certain philosophies inside our society, yet we still have an overwhelming problem. And I think if you look at it, and I think Professor Quigley spoke yesterday, and he's analyzed this very well. If you look at it, though, the primary investment in justice is still in policing, court administration, and corrections. It is not in healing and community outreach, although it's changing. I think that's a change for the better, but it needs a major investment. In our own court, Judge Moran will speak more about innovation in our court with the Cree Court, because I think the Cree Court is one of the most promising developments in the past 5 years for the Provincial Court. There are 3 courts in Saskatchewan. There's the Provincial Court, the Court of Queen's Bench, and the Court of Appeal. The Provincial Court level is, I guess you could say, the People's Court. We sit in 78 court centres across the province. Of that, 18 are First Nations communities, where we go to the community with an agreement with the First Nations community. We don't just drive on there and say we're here to take over. We have agreements. Many of those points are the court operating in the Cree language with Judge Moran presiding. And sometimes people will kind of ridicule us and say, well, a Cree court, yeah, well, that's just a linguistic court. It doesn't mean a lot, whatever. And I think it's important to see that when you have a court conducted in a tribal language like Cree, it is not just a language. The language has the culture. The language has the values. What happens in the Cree court is very different than what happens in another court. And it's very positive in terms of building public confidence in the administration of justice, in terms of building compliance with court orders and a level of understanding. And we really owe a great deal to Judge Moran, because he has gone out there and built it. Because it is not just an institution that you can put anyone in. It has to be someone who has a set of skills and talents that can do it and who is respected. And because of him, I think we've seen some major positive changes in the court system in Saskatchewan through the Cree Court. It still is limited by territory, and he'll talk about it further, but I very much support the work that he does in that area. And I would very much like to see a Dene court develop. I would very much like to see the Cree Court extended. I would very much like to see a Soto court. I would like to see the language, the culture come in on a negotiated and very positive basis. So it's an innovation still unfolding. In Saskatoon, an innovation that I was part of working with the elders of the Saskatoon Tribal Council and the elders in the Métis community. In 2001, we created a circle court in the Provincial Courthouse. It's courtroom number 6. It's a circle. It's to be used for youth, for adults, to have sensing circles, to have different types of discussions. And the elders very much guided the creation of that. At this point, it's more of a physical facility than a set of values, because any First Nations person or Métis person that's been trained and knows the Indigenous values and laws of a circle know what it means to participate in a circle. So the 4 directions of that circle are demarcated. And what that should mean is when you go into a circle, it doesn't matter if it's in a courthouse or where it is, but when you go into a circle and you deal with an issue or a person, you're dealing with all the aspects of that person. You're looking at their physical, their mental, their spiritual, and their emotional. And you are also looking at their life cycle, because the 4 directions represent different stages of a life cycle. There's the infancy, there's the childhood, there's the adulthood, and there's old age. So when you sit in a circle, if you're First Nations or Métis person trained in your legal traditions and trained in it, you will not look at a person as an offender who has committed an offense on an information. That will be relevant, but you will look at them and think, well, what happened to this person in their infancy, in their childhood? If they're still a child, they're still in that stage. Their maturity, their old age, what kind of person will they be when they're older, when they pass through that life cycle? And what are their needs emotionally, physically, spiritually, and intellectually? These are the types of analysis that are part of restorative justice. They're part of Indigenous legal traditions to look at that. And of course, in a circle, people are equal. A judge is not robed, sitting up on a dais. A judge is sitting in a circle, listening and learning. And anybody who's participated in circles in the justice system, many people are critical, say, well, I don't agree these circles, people get off easy in a circle. But if you've actually participated in one, you'll see how difficult and grueling and challenging they are. They take time. People have to be prepared to look inward, to talk, to understand. There has to be a community there. It's a very different process. It's a very positive process. It's an innovation that I think is extremely good. However, it's very limited. And it's limited by time. In our court, in the provincial court level, for our 78 circuit points, our 44 judges, we deal with 500,000 appearances a year. That's how many times a person would appear in our court, maybe 3 times per charge. So when you're dealing with 500,000 appearances per year, there just simply is there's no ability to do the careful work on root causes. Most of what happens is recycling people inside the system. And when you actually say, I'm not going along with this process, I'm going to stop this process and look at someone very carefully, it raises a lot of problems in the system. People become extremely upset about that across the board, because you've slowed down the system that has a certain efficiency, which is processing people quickly and superficially through the system. But of course, the quality of justice is important. And we have to ask ourselves, is one of the reasons why everything happens so quickly because it's all Aboriginal people coming through that system? Is that a factor? I'm not saying it is, but is it? We have to ask ourselves that. And if it is, there's an issue of human dignity at that level. We have to slow that system down and have a discussion and learn about what's happening in people's lives. So there are many innovations. The report of the First Nations and Métis Justice Commission, Justice Reform Commission, has made a lot of positive energy and positive direction for change. There are some very strong recommendations in that report, such as changing the courts themselves, looking at how we can change them to make them more accessible, more open, more representative. Those are all very positive initiatives. And if you look at the chart that I circulated, I've tried to sort of represent where the innovations happen in the system. Down the left-hand side of that chart, you can see there's mediation services. First Nations and Métis people run mediation services throughout this province. Pre-trial, pre-charge, diversion programs. There's court-related treatment services. We have developing a model of a family violence court in North Battleford where if there is an anticipated guilty plea, the person will go through treatment. So there's a treatment program, a batterers treatment program. Court-related information services, that's largely the Aboriginal court worker. An Aboriginal court worker is a lot more important than information, though. They're the linchpin to make the system work. And they're very good. Aboriginal court workers are essential at bringing down the anxiety and the pressure in the court system where people feel caged, because they are. They're often held in less than ideal circumstances. And the court workers do a fantastic job of talking to them and giving them information and representing them in the courtroom, and connecting them with lawyers when needed. And then there are other alternative dispute resolution techniques and circles that are there. All of this goes into that circle in the middle, which is the courts. In the courts themselves, there has not been a lot of innovation other than the Cree Court, some circles. It has not been the site of dramatic innovation. There are discussions, and I think they're worth looking at very carefully, about creating a single trial court. Instead of having two trial courts, have one trial court, and one trial court that has very good links with communities, with services, and with supports. And I think there's a lot of merit in that discussion and having that discussion in Saskatchewan. Then down the right-hand side of the chart, you'll see there's correctional projects, particular programs that are in place for youth, where a First Nations community or tribal council will run camps. Saskatoon Tribal Council and the City Police run camps with young offenders. There's all kinds of various projects throughout the province where people work very hard every day to try and make a difference. The reintegration of offenders is important. We know at Beardy's and Okamasas there's been the federal release program to reintegrate offenders. That's an extremely positive program, very innovative, and I think will be a model. And then there's the ongoing healing circles that are run in First Nations community to deal with repairing the damage that happens when there's offenses. So I do think that changes are coming slowly. Yesterday you talked about independent police complaints processes. That's an important key to it. Thinking that if there's a concern, you can call someone who will take you very seriously, who will investigate it. That's extremely important. All of these things are important, but there still is a great deal of work to do. So I do not think fundamentally that meaningful change will happen until there's a larger number of First Nations and Métis people in positions of leadership and responsibility. I simply don't think it will happen until that occurs, and we're quite a distance from that. So that, in my view, is the first requirement. I would like to see the entire legal profession in Saskatchewan commit to that principle, because the law is a tool for the peaceful settlement of disputes and the maintenance of social peace. And as I said, there are many people in this room and outside this room who every day work on these issues with passion and understanding and hope. I think their work is important. I don't think we should ever denigrate the work that they do and say, well, you know, that's not good enough or what have you. They work very hard to try and bring culture, language, values, and perspectives into the processes and to work with people. And I think we should support them and understand what they're doing. But at the same time, we have to have that support at the very most senior levels of every aspect of the justice system for any of that change to begin. So with that, I thank you. I look forward to, after my colleagues have made their presentations, I look forward to answering any questions that you might have. Thank you.